120 words per minute for 10 minutes. 5 seconds more. Start. This petition is filed by the petitioner praying inter alia for quashing of the letter issued by the respondent rejecting his request for allotment of an alternative plot in lieu of his shop. The petitioner also seeks directions to the respondent to rehabilitate him in lieu of his shop that was demolished by the respondent from where he was running an automotive repair shop. It is averred in the writ petition that in November 1984, the petitioner's shop was burnt down during the riots that took place. The petitioner claims to have filed a complaint with the local station house officer with regard to loss of goods suffered by him, which was duly received. Hence, the petitioner is also entitled to an alternate shop in lieu of his shop that came to be demolished by the respondent for building a flyover in the area in terms of the scheme of relocation that had been implemented. In the counter affidavit, respondent has averred that 3 months prior to the aforesaid riots, for undertaking the work of construction of a flyover, initially the civic authority had carried out a survey of the area wherein 300 persons were identified who were likely to be affected by the construction of the flyover. However, on receipt of a representation from a number of associations in the area that the survey conducted did not cover all the affected units, a fresh survey was conducted and 639 traders who were likely to be affected by the construction of the flyover were identified and were found eligible for allotment of alternative plots. Another survey was conducted subsequently, wherein only 579 traders were found to be eligible. In view of the variations in the survey list, it was decided that such of the units which were found to be common in both the surveys ought to be shifted and the affected persons would be considered for allotment of industrial plots in another area. It is further stated by the respondent that the name of the petitioner did not figure in either of the list. Thus, his case for alternate allotment was rejected. Learned senior advocate appearing for the petitioner submitted that at the time when the survey had been carried out, the shop of the petitioner was closed as he was suffering from a prolonged illness and could not attend to his work. As a result, the petitioner had submitted a representation to the director explaining that his shop existed in the area at the time when the survey was conducted and requesting that his name be included in the survey list by carrying out an on-site inspection. He states that thereafter, in November 1984, the petitioner's shop got burnt down in the riots. The petitioner had then applied to the Relief Commissioner seeking financial assistance. It is submitted that the documents in support of the same have been placed on record. The petitioner also relies on a demolition list prepared by the respondent after the demolition action was carried out in April 1985, in the course of which survey the premises of such of the traders who had reoccupied the site were demolished. In the said list, the name of the petitioner's firm features at serial number 21. It is submitted that from the year 1985 onwards, The petitioner had been making representations and complaints to different authorities seeking alternative allotment, but to no avail. Finally, he received a letter in November 1993 from the commissioner to visit his office, but nothing materialized. The petitioner states that he was made to run from pillar to post in this entire period, but no action was taken by the respondent in the matter of allotment of an alternative plot to him. Finally, the petitioner lodged a complaint for allotment of an alternate plot, which was in turn forwarded to the respondent for appropriate action. The petitioner also filed a complaint with the Human Rights Commission. In September 2001, the petitioner lodged a complaint with the Deputy Director for allotment of an alternative plot and also filed a complaint before the Lok Adalat, but nothing resulted from the said recommendation. Finally, the petitioner approached an advocate to file a writ petition in this court for alternate allotment of a plot and handed over his file and power of attorney, etc., to the said advocate for drafting and filing his case. It is submitted by learned senior advocate appearing for the petitioner that the petitioner remained under the bona fide impression that the advocate who was engaged by him had filed a petition in this court and was pursuing his case. But later on, it transpired that the advocate had not filed any writ petition on behalf of the petitioner and falsely kept assuring him that the case was pending. After waiting for almost 6 years, when the advocate did not furnish him a copy of the writ petition that he claimed he had filed in court, the petitioner got suspicious and realized that he had been cheated. As a result, he lodged a complaint against the advocate with the Bar Council of India. Thereafter, the petitioner approached the Delhi High Court Legal Services Committee to seek legal aid, who engaged the present counsel on his behalf, who has filed this petition, and hence the delay. Learned senior advocate appearing for the petitioner also relies on the decision of the division bench of this court rendered in a batch of matters pertaining to the allotment of alternative sites to shop owners who were displaced on account of the construction of the flyover. He submits that the case of the petitioner also relates to the same area, and he is ready and willing to appear before the respondent for verification of the documents in his possession for the department to satisfy itself with regard to their genuineness. Learned counsel for the petitioner asserts that the case of the petitioner herein is similar to another case for the reason that even in the aforesaid case, the name of the petitioner therein did not feature in the survey list that was prepared, and despite the same, directions were issued by the court to produce the documents in support of his claim, whereafter a report was directed to be submitted in court. In view of the aforesaid facts, this court is of the opinion that the petitioner has been able to satisfactorily explain the delay in approaching the court for the relief sought herein, and he ought to be afforded an opportunity to produce all the documents that are in his power and possession in support of his claim to an alternate allotment under the scheme of relocation by appearing before the director, who shall then examine the said documents and after verifying the same take an appropriate decision thereon in terms of the policy applicable to his case. The petitioner is therefore directed to file a detailed representation along with the supporting documents within 4 weeks. If the respondent is satisfied with the genuineness of the documents produced by the petitioner, an alternative plot shall be allotted to him within 6 weeks from the date of completion of requisite formalities by him. The petition is disposed of while leaving the parties to bear their own costs.